All righty. Good morning to everyone. This is the September, I'm a month ahead, the September meeting for the Oil Conservation Commission. I'm Gerasimus Rosados. I'm the commission chair, and we'll start our meeting now. As always, we'll start with a roll call. So if we can do roll call with the commissioners, please. Go ahead.
Commissioner Greg Bloom for the State Land Office.
Commissioner William Ampoma, designee of the Energy Secretary.
Excellent. And as I said, I'm the acting director of the Oil Conservation Division. And so I'm the chair for the Oil Conservation Commission. So we're all in attendance for this. So we can document that roll call was done and everybody is present. We need to do an approval for our agenda for the September 2024 agenda. So if we can do that.
I move to approve the agenda.
I second.
Awesome. So we can document that the agenda was approved for this session. Next, we have the approval of the August 15th, 2024 meeting minutes. So if we could get an approval for that.
I move to approve the minutes of the August meeting.
Great.
I second.
Awesome. So we can show on record that the meeting minutes were approved. Thank you, everyone. So we have pending cases. The following cases are what we're going to do and have for today. Hello. Did that hurt you? Okay. You took your headphones out. I was like, oh, poor guy. Again, if we could just make sure that we keep the volumes on our laptops and iPads down so we don't have any feedback. So thank you for that. Our first case that we have is case number 24683, application of Western Environmental Law Center and Citizens Caring for the Future Conservation Voters of New Mexico Education Fund, Dene Care, Earthworks, NEVA, and the New Mexico Interfaith Power and Light, San Juan Citizens Alliance, and the Sierra Club to amend the specific rules. This is a presentation of proposed notice of rulemaking hearing. Are the parties present for that? We'll start on this end and we'll just work our way down.
Yes, I'm Allison Beasley, present for petitioners.
Awesome. Thank you.
Jackie McLean with Hinkle Shaner on behalf of the Independent Petroleum Association of New Mexico.
Great.
Miguel Suazo with the Santa Fe office of Beatty and Wozniak, appearing on behalf of the New Mexico Oil and Gas Association.
Excellent. Thank you.
Jesse Tremaine for the Oil Conservation Division.
Thank you, Mr. Tremaine.
Good morning, Mr. Chair. Michael Felderworth with Santa Fe office of Holland and Hart on behalf of Oxy USA, Inc.
Excellent. Thank you, Mr. Felderworth. Anybody else? Okay. So we can get our matter started. Ms. Beasley, please.
Okay. And I do have a copy of the amended notice, if helpful, I can provide. But so since the August 15th meeting, which we appreciate the approval of the request for hearing, we have met since to try to work out this agreed upon notice. And on September 6th, we filed our second amended notice of hearing. It's modeled after notices of hearing in the past from by this commission and other rulemakings, including the PFAS rulemaking. And in short, we are proposing a hearing date of April 14th, 2025 to accommodate requests from the Oil Conservation Division, the Independent Petroleum Association, and other parties. And we will endeavor not to use the entire 2 weeks, but that is the proposed start date to allow time should we need that full 2 weeks. And we are proposing that the parties file full direct testimony and exhibits on January 31st, 2025, and rebuttal on March 7th, 2025, prior to that April 14th hearing. We'd also like to note that we have worked to find times in October for all of the parties to get together and further try to find common ground and work out any sort of substantive issues, work through language, those sorts of things in the petition, and have found a couple of dates in October that we are aiming to do that. And we appreciate everyone's efforts to come to agreement on the notice and to meet in October, and the commission's efforts as well.
Excellent. Thank you. We'll just move right on down and see what everybody else has to say as well.
IPA&M has agreed to the proposed form of order, and we don't have any additions.
Excellent. Excellent.
That also goes for Namoga. We've agreed to the form of notice and no further comment.
Great.
Jesse Tremaine for OCD. Mr. Chair, the parties worked together through a couple meetings to address various concerns, and we encourage the commission to adopt the form of order with any necessary changes that the commission deems necessary, and also encourage for the subject matter and the rulemaking that the commission designate a hearing officer for the hearing.
Okay, thank you. And Mr. Felderwart?
Oxy has no concerns with the proposed notice.
Okay, great.
Mr. Chair, if I may,
Yes, please, Mr. Rubin.
one brief non-substantive comment. The paragraph entitled oral comments. I think to better track the language in the State Rules Act, I would like that read public comment. We could have it read public and oral comment to the parties of any concern. I just want to make sure public comment is highlighted. Okay, so Ms. Beasley, if you could prepare, I don't have a Word version of this. You could send us a Word version with that change.
Absolutely.
Okay. That's all I have, Mr. Chair.
Okay, excellent. Commissioners, do you have anything that you wanted to add or questions? Please.
Mr. Chair, I note that Mr. Tremaine asked that we appoint a hearing officer, and I'm just unclear, can't remember at what point we would do that, if that's an action we would take today via vote, or we would do it at a later date.
Mr. Rubin, did you have any suggestions on that?
Mr. Chair, Commissioner Bloom, the Open Meetings Act sometimes is a bit of a constraint in these matters, and our agenda only lists the matters to be heard as presentation of proposed notice of rulemaking. So I think in an abundance of caution, we do not have the commission formally act by appointing a hearing officer today. However, that is something that I believe I will check the rules, but we might be able to get that done without commission order if the chair does so, unless if someone else knows if the rules say otherwise.
Mr. Tremaine, did you have any objection to that?
No objection. I mean, that's the decision of the commission. I think it was discussed in prior hearings. My understanding and interpretation of the rules is that that's a procedural decision that can be made by the chair, but I will defer to the decision of the commission. I think that there are going to be some other matters to discuss in this case over the coming months that it would be helpful to have a hearing officer in place for. But if that's not the case, then we can accommodate either.
Okay.
Either way. Yeah.
Mr. Rubin, then if you would just follow up with the commission and just let us know exactly, and then we could figure out.
Okay. Yeah, I think the best course is either if I'm correct that the chair can appoint a hearing officer to do it in that manner, or make sure it's on the next meeting agenda. Either way, and I think Mr. Tremaine's point is well taken that we want a hearing officer in place sooner rather than later.
Sure.
Okay.
We'll work it out and we'll get it up. Excellent. So does, as far as the commissioners, the April 14th starting April 14th work for everybody? I'll start. Commissioner Bloom. I'll start asking.
Let me check here. I'll give you
It works for me, so
Commissioner Mpoma, it works for you?
yes.
Okay.
Yes, that works for me as well, Mr. Chair.
It works for me also. So we'll start it. We'll get the rulemaking hearing starting on April the 14th of 2025. We'll set it for a period for 2 weeks, Sheila, if we can do that. And as you mentioned, Ms. Beasley, you didn't think it would go for 2 weeks, but better safe than sorry, right? Okay, excellent. If no other, Dr. Mpoma.
Yeah, Chair. So can we have clarity getting closer to the hearing date to make sure if we know the timeline, because I need to make travel arrangements as well. So.
Right. And Ms. Beasley, I think since Welk is the petitioners for this, you would just follow through to make sure that we have timelines and all that, correct? Excellent.
Yes, as best we can. Absolutely.
Okay. Alrighty, so I think that's set for that particular case. Thank you to all the parties for that one.
We do need a motion.
I'm sorry, we need that motion. Haha.
A motion to approve the proposed notice as amended by council.
Thank you. So we need a motion to approve for this hearing.
And I so move.
I second.
Excellent. Motion has been granted.
Thank you.
Thank you to everybody. I still haven't had enough coffee this morning, so I'm running late. Sorry. As people are getting seated, our next is the consolidated cases by Goodnight Midstream and Empire, New Mexico. They are case numbers 24123, 23614 through 23617, case number 23775, and case numbers 24018 through 24027. This is a motion from Empire for clarification on the scope of hearing and burden of proof. To make sure that the parties are all here. Is everybody here from the parties? I'll start here from my left and we'll go through. Ma'am, please.
Thank you, Mr. Chair. Sharon Shaheen. With me today is Ernie Padilla, and on the internet is Ms. Hardy, who will be doing the argument on the motion today.
Excellent. Thank you. Mr. Padilla, she just introduced you. So did you have anything else?
I don't have anything else. Thank you.
Excellent. Thank you.
Good morning, Commissioners. Miguel Suazo with Beatty and Wozniak appearing today on behalf of Pilot Water.
Excellent. Thank you, Mr. Suazo.
Chris Moander on behalf of the Oil Conservation Division.
Okay. Thank you. Thank you, Mr. Rankin. Anybody on, Ms. Hardy, I know you're on Teams. Was there anything you would like to add?
No, good morning. Thank you.
Great. Thank you. Anybody else on Teams? And I apologize, I can't see the screen, and I didn't load it up on this computer. Is this one on?
Good morning, Commissioners. Matt Beck on behalf of Interveners Rice Operating Company and Permian Line Service, LLC.
Thank you, Mr. Beck. Appreciate it. Anybody else? Okay. We'll start with you, ma'am, and here. Oh, actually, Mr. Rubin, I know you wanted to start off this particular one this morning, so if you wouldn't mind.
Thank you, Mr. Chair. I do think it might be helpful if, for the benefit of the various council here, that they hear what I think of the, I've had the luxury of reading all the pleadings, and I would like to perhaps offer the commissions my advice as to what this all means. And I think it might be helpful then so that the council can then direct their comments, their oral argument accordingly, to the extent that the commission feels like I have some sage advice on this. So this is clearly an issue of statutory interpretation of a statute the commission is entrusted with. This is clearly something for the commission to decide, not the hearing examiner. There is, of course, the option of having the hearing examiner take argument on this and make a recommendation as part of his report. But to the point of the motion, there might be some efficiencies gained by the fact that there is direction and perhaps even an order from the commission ahead of time. And so again, this is the interpretation. As I see it, these motions come down to interpretation of 70-2-12B4 under the enumeration of powers, all the things that the commission and the division may do. I think that's a hard may because it lists a list of horribles that need to be prevented. And I think that goes to the point of Empire that the way this statute is constructed, it lists not just in paragraph 4, but in those other numbered paragraphs, all the things that this commission is entrusted to prevent. I think some of the controversy is because paragraph 4 groups together two things by subject matter, because they both deal with produced water and the chaos it can cause for pooling. And so I've looked at the structure of this particular paragraph B4. And it says basically to prevent the drown, well, I'll read it, to prevent the commission may issue orders or to prevent the drowning by water of any stratum or part thereof capable of producing oil and gas or both oil and gas in paying quantities, and to prevent the premature irregular encroachment of water or any other kind of water encroachment that reduces or tends to reduce the total ultimate recovery of crude petroleum, oil or gas, or both oil and gas from any pool. So I think while I do understand the point made by Goodnight that there is an and here, and so the argument is that Empire must prove both of these things, and therefore it is a logical necessity that they establish the paying quantities provision of the first part. However, the fact that the statute is the intent of the statute is to list all the things that must be prevented, and further, it doesn't simply say to prevent X and Y. It says to prevent X and to prevent Y. It adds a verb in there. And of course, as lawyers, we sometimes dwell too much over what the intent of an and or an or a comma is. I think it is telling. And I think the legislature intended to reinforce the intent that you need to prevent both things in any order or rule. And so based on that interpretation, I would strongly advise the commission that if Empire can prove either of these things, an order should issue accordingly. And now to the point of Goodnight, you do need to read everything in paramateria, consistent with the other statutes and consistent with each other. And would it not be a problem if we have notions of the oil and gas in paying quantities not somehow incorporated in the second part of B4? Well, it's an interesting structure here because the first part, the preventing the drowning of water by water of any stratum. This first part refers merely to stratum, which, and you all can correct me if I'm incorrect on this, but stratum generally refers to structures, refers to the architecture, if you will, of what we're dealing with, whereas the second part deals with the pool, which is the oil and gas. And so I think A and B are intended to cover either one. There's things we must prevent with respect to the structure and things we must prevent with respect to the oil and gas. So that is why I think you can read these separately. And each one, this commission should not enter any orders or pass any rules that would violate either of these things. But I do not think, based upon this, that if Empire let's say Empire is necessarily out of okay if it only simply tries to prove the second part, because the second part, the encroachment that reduces or tends to reduce the ultimate recovery of crude petroleum or oil or gas or both from any pool, that is taken directly from the waste definition at 70-2-3. A, almost the exact same language. So I think reading these consistently and with the overall entrustment of the legislature that this commission shall prevent waste, it would seem to me, although we don't have to decide this today, that some notions of practicalities or profit, if you will, need to still be read into this second prevention, because if let's say in this particular stratum if this particular pool does not contain enough oil or gas for it to be worth anyone's while or profitable to extract it in the first place, I think that there's no waste. Inherent in waste are notions of you want to prevent. Waste is a prevention of oil and gas that otherwise would be extracted, and it would only be extracted if there was a profit motive to do so. So with that, I think that the commission should certainly hear from counsel on this, because there are certainly different ways to interpret this. I do I do feel like the way I'm proposing, I think is my goal is to make sure that whatever the commission decides is going to be upheld on appeal. That's my motivation. So I stand for any questions from the commission, and then at the commission's pleasure, they could hear argument from council.
Thank you, Mr. Rubin. Commissioners, did you have any questions?
No, Mr. Chair, but I would like to hear from the parties as well, as Mr. Rubin suggested.
Okay.
Yeah, I would like to hear from the parties as well. So
I agree. I think I'd like to hear from the parties also. So I think that part's unanimous. So Mr. Rubin, then procedurally from this point, we could turn to the parties now, correct?
Yes, Mr. Chair, members of the commission, I think it's appropriate for the parties to make their presentations. My hope is that if anything I said will help focus the argument, that's all.
Okay, excellent. Thank you. So we'll start as I did earlier. I'll start here on my left and we'll work through. So why don't we have you start, ma'am, and we could go from there.
Thank you. Ms. Hardy is going to speak on behalf
Ms.
of
Hardy's going
Empire.
to speak. Okay, Ms. Hardy.
Yes, good morning, Mr. Chair and Commissioners. And I would like to share my screen here so we can look at the statute. And I agree with Mr. Rubin's interpretation. Can you see my screen or not?
No, not yet.
Okay. Let's see here.
There we
There.
go.
Can you see that? Okay.
Yes.
Okay. So of course, when you're interpreting statutes, the goal and requirement under New Mexico law is to construe the entirety of the statute at issue along with the other provisions. So those would be the provisions of the Oil and Gas Act. So as Mr. Rubin stated, this statute, which Goodnight is relying on, is a list of powers that the commission and division have. So it's not a burden of proof statute. It's a list of powers that enumerates all of the different matters that the commission and division must address and may make rules and orders to address. And so Goodnight is relying here on this subpart B4, and they are arguing, as Mr. Rubin mentioned, that Empire cannot prevail on its applications to revoke Goodnight's permits unless it establishes that both of these two items in subpart 4, that oil and gas will be reduced, the production paying quantities will be reduced, and that the water encroachment reduces or tends to reduce the ultimate recovery of hydrocarbons. And I think they are misreading that provision in many ways. First, they are using that reference on production and paying quantities to supersede any other provision of the Oil and Gas Act, including the other subparts of this specific statute. So that has never been held by the commission or division to be the only way that a party can oppose an injection application. And I want to be really clear that that is what Goodnight is arguing here. They are arguing that the commission and the division cannot act to deny injection applications unless the opponent proves a loss of production and paying quantities. That's not the law. That's not in the Oil and Gas Act. It's not in the commission or division regulations. And that has not been held in any order, including the order in which the division denied Goodnight's permit to inject into the Piazza well. That's just simply not the law. And when you look at this subpart B of the statute, it also provides that the commission and division under subpart 2 are to prevent petroleum, natural gas, or water from escaping from strata in which it is found into other strata. That's another provision that is relevant here and that the commission can act on. And then also, when you look at subpart 7, that provision requires the commission and division to ensure that wells are drilled, operated, and produced in such a manner as to prevent injury to neighboring leases or properties. So you have those two provisions as well as subpart 4, that all of those items listed allow the commission to deal with Goodnight's applications and potentially deny them if they cause concerns on those issues. So I think really here, that Goodnight is taking one subpart in isolation. They're misreading that subpart. They are basically cutting it out of the rest of the statute and saying that that supersedes other provisions as well as the rest of the Oil and Gas Act, which is just simply not the way that statutes are read in New Mexico. And it would hamstring the commission and the division's ability to address injection applications in this state and ensure that they do not cause waste and violate correlative rights. So I think it's clear here what the commission can do, and it can act under any of those provisions. And it's simply not correct that Empire can only prevail if it shows a loss of production and paying quantities. That's just not correct. And that's not what the commission should find here. So I think the argument is actually pretty straightforward, and I think the statute is straightforward. And another point, and we made this in our reply brief, is that Goodnight, in arguing that that one provision uses the word and, well, the entire list of powers also uses the word and. When you look at it, there are 21 or 22 powers enumerated there. So if Goodnight's interpretation were correct, that would mean that the commission could not address any issue unless all 22 of those are satisfied, which is, of course, not the law. So the Goodnight's argument lacks merit and should be rejected, and Empire's motion should be granted. And I don't know, Mr. Rubin, if you would like us to deal with the burdens of proof, because that was also raised in the motion, and I know you didn't make comments on that, but I'm happy to address that as well. The other matter addressed by our motion is just really a clarification of very clear law, which is that each party bears the burden of proof on its own applications. That should not be controversial. In fact, it's not controversial under the law. It's very clear. For some reason, Goodnight is trying to convolute that and argue that Empire somehow bears the burden of proof on all of the applications, including Goodnight's applications. That's not the law in New Mexico. The case they cite is a Colorado case from the Court of Appeals, which states that the party seeking to change the status quo bears the burden of proof. That is not a novel concept, and when you read the case, it's not saying anything different from the fact that the moving party bears the burden of proof. Here, Empire bears the burden of proof on its applications to revoke, and Goodnight bears the burden of proof on its applications to inject. Goodnight is seeking to change the status quo by obtaining injection permits that it does not currently have, and also to increase its injection rate in an existing well. So it clearly bears the burden of proof on those applications. Empire bears the burden of proof on its applications. I think that's a pretty clear principle of law that really should not be up for debate. Goodnight argues that Empire somehow now bears the burden on Goodnight's applications because Goodnight has established a prima facie case based on its testimony that's been submitted. Well, that's not correct. Empire has opposed Goodnight's applications and also submitted testimony and exhibits in opposition to those. So no fact finder has held at this point that either party has met the burden of proof. So if Goodnight's argument were correct on the burden of proof, then Empire has already met its burden on its own applications. So it's an inconsistent argument on the part of Goodnight. I don't think it really makes any sense, and it's inconsistent with well-established law. So I think really to sum up here, Empire's motion should be granted. The commission should clarify that the issue in these cases is whether Goodnight's injection is resulting in waste or violating correlative rights, and clarify that each party bears the burden of proof on its own applications. So I'm happy to answer questions if there are any.
If I may respond to Ms. Hardy's comment about the burden of proof. I did mention that, and I should have. The way I see it is the burden of proof is an issue when, or typically does not wind up being an issue when both sides present their case, and it simply comes down to a matter of preponderance of the evidence, which is what the standard is here. So it may, burdens of proof can come into play. I would recommend that that part of the motion not be, the commission does not necessarily have to decide that today, but to leave that to the hearing. And if Mr. Harwood, as hearing officer, believes that somehow the burden of proof is how to decide a particular issue, that would be his recommendation. But I suspect there is a very good chance that he will not make a recommendation based on the burden of proof anyway.
Okay, thank you, Mr. Rubin. Commissioners, any questions?
Yes, I do have one or two. So, Mr. Hardy, I want to know, when you talk of ROZ, ROZ need to have a minimum saturation before it can qualify to be an ROZ. So if you say that Empire doesn't necessarily need to prove that there is, let's say, some amount of oil in there, I'm a little bit confused as to how you're going to prove that there is an ROZ. So if you can comment on that.
Sure, Dr. Ampama. So Empire absolutely will establish that there is an ROZ. And we are providing information on economics in our testimony as well. The issue here that came up on this motion is pretty specific, and it is that Goodnight has argued that Empire cannot prevail unless it establishes a reduction in production and paying quantities. That is a specific term of art and analysis. Under oil and gas law, to determine production and paying quantities, you look in hindsight and evaluate cost and revenues. It's a very specific analysis. So that is a narrow view that Goodnight has. And that's not the law. I think Empire is absolutely going to establish that there's an ROZ that can be produced. The issue here is whether we have to establish a specific loss of production and paying quantities. And that's something that is not required, and it's not appropriate here based on the posture of this case, because we haven't implemented a tertiary recovery project yet. So you can't look in hindsight at economics and cost and revenues of a specific production plan or unit. And that's what Goodnight is arguing here. So that's the issue. It's not that we don't have to prove any amount of recovery economics, because that's not true. Because obviously, if there was not a sufficient amount of oil in the raws, we wouldn't be here. Does that answer your question?
Yes, thank you.
Okay, thank you.
Commissioners, any other questions? Okay, there were no other questions, Ms. Hardy. Thank you.
Thank you.
Appreciate it. Mr. Suazo, we'll move on to Mr. Suazo.
Thank you, Mr. Chair. Actually, Pilot has not submitted briefing for today's hearing. We may have some comments at the close of the other party's briefing, but just as a reminder, we have intervened in the case, and Pilot's interests in the EMSU are potentially impacted by the findings here.
Okay, thank you, Mr. Suazo. Mr. Moander.
Good morning, Commissioners. Mr. Chair. So the OCD did file a response in this matter, but took a different tact. And I'm going to explain a little bit of that here. So first off, I do think that Mr. Rubin's correct that we've got issues here of statutory interpretation. OCD took a look at other provisions that fall within 7-2-12B. As a starting point, Empire's response or reply states that it does not dispute the commission has jurisdiction over the division's water quality concerns, or that the concerns may be addressed at the February 2025 hearing if the commission determines it's appropriate to do so. OCD's position is it's absolutely appropriate, and OCD's case fits within the scope of the original scheduling order. And I'll turn to that here. OCD quoted directly out of the scheduling order, in particular, paragraph 3 on page 2, that such evidence, testimony, and legal argument shall be limited to applications and wells by Goodnight or by Empire New Mexico LLC within the EMSU. Fairly straightforward sentence. The focus here is the applications and wells. Now, OCD's position is that under 70-2-12, there's discussion, of course, about the drowning of strata, which has been discussed and will be further elucidated by council. That's what I anticipate. But OCD is much more interested in a very key provision here. It's actually subparagraph 15, which states in relevant part that OCD has to regulate the disposition, handling, basically the touching, if you will, of produced water during or for reuse during oil and gas operations. Again, I'm paraphrasing, but the key part here is including disposal by injection pursuant to authority delegated under the Federal Safe Drinking Water Act in a manner that protects public health, the environment, and freshwater resources. So OCD looks at this matter. When you look at what the commission originally ordered, disposition of produced water is arguably the key oil and gas concept in play here, which is also going to be modified by concepts of waste and so on. But when you look at that sentence from the scheduling order, this is exactly like OCD's case is precisely at the heart of the case. While the private parties have concerns about waste and interference with their private operations, OCD has an overarching federal duty, not a state duty, but one from the federal government under the Safe Drinking Water Act, to the point that it's actually put into statute. So everybody knows that that's part of OCD's obligation. It's not a regulatory decision. OCD's real argument here, though, on a more substantive level, is that it's OCD's view that the commission can't really consider the applications of either Goodnight or Empire without factoring in information about Class 2 UIC permitting. That's arguably a foundation for the operations of both operators, which should be addressed in some form in their cases, or at least touched upon. But secondly, is that OCD intends to flesh that out more fully and bring as much information as possible to the commission that is up to date to show essentially where things were, where things are, and where the future concerns lie about these injection wells and these programs. So OCD not to belabor the point, but it seems fairly straightforward that OCD's case is encompassed by the scheduling order, and that the fact that OCD didn't finally tip its hand until its witness testimony came out is not a fault of OCD's. OCD understood the scheduling order and has operated accordingly. So there was no, in OCD's position, from OCD's position, a surprise or anything. Discovery could have been conducted. All that sort of investigation could have been had. It wasn't, and that's not to cast aspersions upon any one party, but that's a part of the discovery process OCC permitted. So to summarize, based on the scheduling order 70-2-12B and some of the enumerated sections, in particular, a reference to the Federal Safe Drinking Water Act, OCD's position is its case is viable, appropriate, and acceptable, and for hearing in this matter, and that any objection to it is off base as a matter of law and matter of fact. And I'm happy to answer any questions that the commission might have.
Thank you, Mr. Moender. Any questions from the commission? Dr. Mpoma.
Yeah, so I want to know OCD's position on this particular motion on the floor. If you can tell the commission, what is your position on Empire's motion?
Oh, our position is that this is an odd motion, Dr. Mpoma, from the standpoint that what you're asking OCD is to pick a winner here, pick a side that they prefer. Arguably, and this is always OCD's concern, to potentially express a particular institutional bias one way or the other at this point. OCD's position is that the hearing officers made determinations that have led to the appeal to the OCC. That was made through a hearing officer. OCD is not picking a particular party to favor in this action, is interested, very similar to your request, Dr. Mpoma, about questions on enforcement and so on. OCD wants to see what all comes out of this, but the decision point, unfortunately or fortunately here, is with the OCC. OCD's case is segregated from those cases and takes a different approach, which is more focused on the issue of the drinking water injection volumes and so on.
So let me be clear. So during the actual hearing, is OCD going to more or less try to be in the middle without like bringing in experts to prove that whether the San Andreas or the subject formation based on the state analysis, whether it's a production zone or is a potential injection zone?
So, Dr. Mpoma, I always enjoy your questions because you definitely put me to the press, and I appreciate that. OCD's position in this case is that the San Andreas has potentially serious problems in terms of things like communication with the Hobbs channel and a negative impact on drinking water. In a sense, one could construe OCD's position as an overriding position to what the parties are seeking, and that what OCD wants to see is a pilot project enacted to ensure that the water and drinking water integrity in the region is secured. And if it is not, that information will be used to determine future OCD policy positions. And that does include, because I know that the parties have produced a humongous amount of paperwork to the commission in this case. Some of what OCD will be talking about will be issues of like what's going on with injection on a practical level, what is occurring in these zones potentially, but the crux of it will not be on which operator has a better case. It is going to be centered on what has happened with all the operators in the area vis-a-vis the water quality issue.
Thank you.
Commissioner Mpoma, members of the commission, it is clear that you cannot compel an answer from Mr. Moander. And so I think he has stated the position of the division quite succinctly. Thank you.
Thank you, Mr. Rubin, for that clarification. Commissioner Bloom, did you have any questions? No questions. Excellent. Thank you, Mr. Moander. Mr. Rankin. Ms. Hardy, can you hear Mr. Rankin?
I cannot hear Mr. Rankin.
Please.
What is that?
That's much better.
Yes, now I can hear. Thank you.
Ms. Hardy, you can hear him now?
Yes, thank you.
Excellent. Thank you.
All right, there you go. So a couple of issues. I'm gonna start with the burden of proof and touch on that quickly. Well, first I would like to address sort of the way this issue has come about, the briefing has come about here. The motion here seeks clarification of the commission's order. And I guess my comment on that is that the issues that have come about in this motion have come about on sort of an ad hoc basis. I mean, the Empire sought clarification of an order that doesn't address burden of proof, doesn't address the elements of the claims. So I don't think that it's really a proper motion in that sense. And if the commission has concerns or would like the parties to address these issues, then I think it may be proper to have proper briefing on it so that we can actually address it in the proper scope. The commission's order on the scope of hearing was elicited through the pre-hearing scheduling order, and it asked the parties, asked Goodnight to define or to make a motion to clarify or to limit the scope of the hearing. In doing so, the issue was what cases and issues should be heard, not what the burden of proof should be. So at no time in the briefing or previously has the commission considered burden of proof or elements of these claims. In fact, when the order was issued, what the commission said was that the parties should address such legal arguments at the time of the hearing. And so the briefing here has been a little bit ad hoc, and I would posit that the motion itself, the issues have sort of come about through the process of briefing and now through argument. So I would say that if the commission has concerns, I think it's a valuable exercise, would be to separately brief these issues in advance of the hearing so that the commission has a better understanding of, I think, what the law is and what the arguments will be. So that's the first thing I wanted to say, because the way this briefing has come about and the issues have been articulated is sort of a process. It's been a process through the briefing, and now we're hearing some additional input and thoughts. So I would just say that there's no real. I understand that there's some benefit to having some clarity on some of these issues in advance of the hearing. To that point, we've already got our direct testimony filed. Okay, it's already been submitted. So each party has already made their direct case. So there's no real rush or need to rush to make this decision. We've already all made our direct case. So on that point, I think if the commission would like further assistance from the parties to help articulate the burden of proof and the elements here, I think we should do it in a proper sequence so that it's not on an ad hoc basis and it's not on a motion to clarify an order that doesn't even address the issue. So I would urge potentially, based on the discussions today, that the commission consider directing the parties to have a separate under a separate briefing schedule to address more specifically the specific issues that the commission's concerned about, so that the parties can target and direct their briefing and legal analysis in a way that's most helpful. So that's my first comment on the issues that are before you today. I would say it'd be more helpful potentially for you. I mean, it would have been a different situation, I guess, if we hadn't already presented our testimony, our direct testimony. And I think it's important that we have. Each party now has put forward what they believe are the facts that support their case. So the next thing I want to address is the burden, the burden of proof issues. We've gone back and forth on this a little bit, and it probably sounds like a matter of semantics, like who has the burden? It's your burden, it's my burden. No, it's like a hot potato game, right? But it does, I think, have some importance here. And I want to point out a few things because I think it's important to understand, what I understand the division's position to be, what I understand the case law to be. The burden of proof, I think, does ultimately matter here, and I don't disagree that ultimately it's a preponderance of the evidence. Like what does the evidence show, and ultimately it's the commission's duty as the fact finder to weigh that evidence between our case and their case and the division's case. But as to the burden, I think it does matter to some extent because I think it ultimately falls here on Empire. I'm not saying that Goodnight does not have an initial burden to make out a prima facie case. And a prima facie case is simply one where we are able to demonstrate through a preponderance of the evidence that the elements that we are required to show to establish the propriety of injection have been met. Okay, that means we have to demonstrate to the division's satisfaction that we've met the elements required to receive authority to inject under the UIC program, and that we have demonstrated that our injection is not going to result in waste or impair collateral rights. That's our initial burden. And understanding Ms. Hardy's point that to this point, there's been no determination one way or the other about, who has, if any party has met that initial burden. No doubt that has not happened. Our view, however, is that we have met that burden. And now I think it's important to consider here, I'm going to point out, what the division's own testimony is here as well, that here there is 80 years of precedent where the San Andres in this area has been treated under numerous regulatory bodies as an aquifer, as a water management zone. The division itself has authorized disposal within the EMSU and around the EMSU for more than 60 years in an offsetting acreage for more than 80 years. That is a regulatory fact. That's the status quo. And within the documents, the formation documents that created the EMSU itself, the evidence presented to the commission confirm that the San Andres was not a hydrocarbon bearing zone. It was a water management zone. It was included in the EMSU for the sole purpose of providing water for the water flood operations. That's the status quo. Now, after more than 80 years, and after numerous operators have been authorized for injection and have been disposing into the zone, Empire is now suggesting that actually, oh no, this is not a water management zone. It's not an aquifer. It's a residual oil zone. It's hydrocarbon bearing. To make that change will require undoing and unwinding decades of authorizations, approvals for injection, of a determination by the state engineer's office that this is an aquifer subject to prior appropriation and beneficial use. It's a massive undoing of decades of regulatory approvals and authorizations. So in that context, it requires a firm showing that, sure, there's oil down there and it's going to be economic and it's going to be profitable, and that burden ultimately falls on Empire. And I'll share my screen here. I'm just going to point out, I mean, the division has taken this position fairly clearly in its direct testimony. Mr. Powell, and I believe I'm interpreting this correctly, it has taken the position that it's OCD's position, and in this case, the burden lies with the operator moving for an adverse modification to demonstrate to the OCC that the level of information to meet such a threshold to justify an order modification with a particular emphasis on the factual predicate required. Excuse me, my mouth is turning like a cotton here. Too much coffee this morning. But that statement is in the context of several previous statements that Mr. Powell made around the concern of undoing decades of authorizations for injection. I didn't highlight the rest of this here, but his point throughout his testimony is that operators are relying on the injection permit as a bedrock for their investment in a given well or wells. It doesn't create a property interest, but it does authorize activities, undertaking of investments, and it's been that way for decades. And it's not just Goodnight, it's Pilot, it's Rice. Pilot has more than a dozen wells pending approval in the San Andres. This case has a substantial bearing on what is going to happen with Pilot's applications. So what Mr. Powell is saying here, as I understand it, is that given the reliance, given the decades of authority that have been granted in these cases, it's ultimately Empire's burden to show that in order to revoke these authorities, that the approvals were wrong and that there's definitely oil in paying quantities. That's the way I've interpreted this language. Now, he doesn't go so far as to use the word paying quantities, but it needs to be a clear showing. That's my understanding of the division's position. And that's why I think it's important to keep in mind the burden of proof. Yes, we have an initial burden. We are the applicant in our cases, and we must make a prima facie showing sufficient with a preponderance of the evidence to make our proof. Now, I don't have them all up here, but if you review all the cases authorizing injection, all the previous cases in which Goodnight has gained the approval to inject into this zone, Goodnight has shown repeatedly through hearings that their injection will not cause waste, that their injection will stay within the zone. The division has asked repeatedly questions about the Capitan Reef, and Goodnight has addressed those questions and demonstrated to the division's satisfaction in every instance that there would not be impairment to the Capitan. So our view is that is the status quo. This is a zone that has been approved for decades, has been demonstrated to be safe and effective for disposal. I understand that there's questions and we want to make sure that everything is demonstrated to the satisfaction of the commission. And we believe that we've done that in this case. Now, as to the elements, I think that the statutory interpretation is an important, obviously it's the basis of this question. And I don't disagree that when you're interpreting the Oil and Gas Act, you must read the statute as a whole. And I'm not going to sit here today and go through, a detailed statutory argument because I don't think it's necessary. And that's why I would argue that, if the commission finds it useful, that we have separate briefing on that issue to address it. But I do want to say that the notion that economics is not, or paying quantities is not a consideration that the division ever looks at or commission has ever looked at, or it's not the foundation for a decision about evaluating the authority to inject. It's just not true. Every case, when there is a claim that there's offsetting production, every case before the division and commission is always evaluated whether or not that claimed production is commercial, would produce in paying quantities, or would be economic. The commission has used those terms interchangeably. I just pulled up a few cases to show, and I didn't find anything to the contrary. Okay, whenever there's a claim that there is potential for production in paying quantities, the division or commission always evaluates the economics of the production. Is it economic? Is it commercial? Okay, here's a case number 8234 under order R7637. The showing was that there is no commercial oil and gas production within the zones that they're proposing to inject into. Therefore, it will not cause the premature drowning by water of any zone capable of producing commercial quantities. Okay, the commission has always interpreted that requirement together. If they're not separate, paying quantities and premature drowning have always been evaluated in the context of whether or not the production is economic. If the production is not economic, there's no waste. If the production is not economic, there's no impairment to correlative rights because there's nothing to produce or there's nothing of value to produce. That's inherent, as Mr. Rubin said, in the definition or the term itself. Here's a case that was before the commission. Although not stated explicitly in the rules, injection operations must not cause waste or threaten correlative rights. Apparently, to address this issue, the parties focused their presentations on the potential productivity of the San Andres and Glorieta formations. The witness at issue here testified that no well in the immediate vicinity of the proposed injection well produced oil or gas from either the San Andres or Glorieta. Data demonstrates that the water saturation levels in the San Andres in the vicinity of the injection exceeds 94%. It's not economic. The zone is a water zone here in this case. They go on to determine that based on the water saturations, it's unlikely that any of the hydrocarbons would move to a wellbore could be recovered. So recoverability is a key issue. Okay. Finally, based on all this, the commission finds it appears that the Glorieta and San Andres are wet and will not produce commercial quantities of oil or gas. Commercial production is always the basis for the decision. Here's a case before the division. The BLM was concerned that a well that was proposed to be converted to injection was still paying in production and was still producing in paying quantities. Okay. This is unusual because you never usually see the BLM show up in the division or commission, but here they do because they're concerned about the fact that this well was still producing in paying quantities. Well, the division, upon analysis, determined that it was a stripper well. It was still producing some oil, okay, but it's not economic. And in fact, that well would serve a better purpose if it were converted to injection for disposal. So the division found that even though it was still capable of producing, it was not economic, and they allowed it to be converted to an injection well for disposal. Okay. Here's another well that again was producing from a zone, but it was producing in such small quantities that it was not economic. Okay. So again, the basis for decision is the producing well, is the zone from which it's producing capable of producing and paying quantities? If it's no longer the case, even a zone that has been known to be producing, known to be productive, has been allowed to be a source for disposal. And it goes on. I mean, again, every single case, if you look it up, you'll find calls the same thing. Economics, paying quantities has always been the basis for decision. Here, a well is proposed for disposal into the Bell Canyon. The determination was that there was no current commercial production from the zone in the immediate area around the well. A company came in, was concerned about the potential for impairment based on the injection. The division found that based on this provision that we're arguing about today, requires the commission to prevent the drowning of strata capable of producing hydrocarbons in paying quantities. The commission finds that there was past production and there is potential future production in the Bell Canyon. And therefore, they determined, based on their requirement to prevent the drowning of strata, that the well should be denied. Okay. Again, the question is it capable of producing in paying quantities? And here they found that it was, because there was prior and existing production offsetting. Here's a case, a more recent case where the division approved an NGL well for injection. They were concerned about the potential impacts because there was some offsetting production. So they required the operator to provide copies of subsurface logs to correlate the stratigraphy and to reassess the economic evaluation for hydrocarbon potential prior to injection. Okay. Again, the basis for a decision about whether injection is proper in a zone that may produce is whether or not the production is economic. Because without an economic determination, if it's not economic, then there's no waste, there's no impairment to correlative rights. Okay, so I won't belabor the point, but in every instance, the commission has always held, and the division has always held, that the requirement ultimately at base is whether or not production is economic. Stop sharing there. What's I think was interesting about this case, this argument and the motion here, is that Empire appears to have shifted its position away from claiming that Goodnight's injection is drowning out the San Andres and the Grayburg, and is dissociating itself from that claim because of this issue and concern about economics. Because in their direct case, they did not present an argument that the production will be economic. It's not in there. And it's not in there because I don't think they can't show it. So you can understand what their concern here, because they don't have a case to demonstrate that there's any oil in the zone capable of being produced in economic quantities. Instead, they're focused on the concepts of waste and correlative rights. And I think reading the statute as a whole and understanding the way the commission has interpreted and applied that statute, it's important to understand that, economics is the basis of all these decisions. Because without showing that the zone is capable of producing economic quantities, there's no waste and there's no impairment to correlative rights. Yes. The arguments that the statute and the language in the phrase producing and paying quantities, Empire has applied a case law authority that addresses that concept in the context of lease terminations. Private lessors will come out and argue that operators are not producing and paying quantities, and therefore, under the terms of the lease is terminated. My view is that language and that case law is not applicable here to the statutory language. I think the commission has broader flexibility to apply that term and phrase in a way that is not so wooden. The point is that Empire must show, in order to upend 80 years of authorizations, injection, and disposal, they must show that that the production they're proposing to generate from this zone is economic and is capable of producing in paying quantities. It's no different than what they would be required to show to the commission in order to obtain the right to do so under the Statutory Unitization Act. It's no different. They have to show that the costs are going to be less than the value of the production plus a little bit of profit. And they'd have to show that in any event in order to undertake a EOR project under the Statutory Unitization Act. It's no different. And to say that they can't do it now is, I think, is telling, because certainly they would be required to do so under the Statutory Unitization Act. So my view, just and to close, I appreciate your patience with me, but I think this is important, is that if the commission is undecided or has additional concerns, I think it would be appropriate to direct the parties to have a structured briefing around this issue so that, and we can directly address the questions that the commission has. Because I feel at this point, the briefing has arisen through a sort of ad hoc approach in a manner that I think is not maybe as helpful to the commission. So I would ask if the commission does have any concerns to direct us to answer specific questions and do so in structured briefing. And with that, I would stand for any questions.
Thank you, Mr. Rankin. Any questions from the commissioners?
No, Mr. Chair.
I do have one. So, Mr. Rankin, assuming 80 year of, let's say, state engineer's office demarcating the MSSU as injection unit. So do you have a problem with like advancement of technology where ROZs has evolved over the years? So do you have a problem with the advancement of technology, to explore for resources that could be in the San Andres?
Not at all, Dr. Empoma. In fact, I think it's important. And there's some of these cases that I cite to. In fact, there's discussion about the advancement of technology. In one case was horizontal well development. And Mewburn was making the argument that whereas previously some zones were considered to be uneconomic with vertical drilling, such as I think the brush heat, the DMG. But with the advancement of horizontal drilling, some of those zones now have economic prospectivity. And so, of course, as the technology evolves, there's a possibility that some zones that were previously non-economic may become economic. My point only is that if you're the party that's making that claim, it's your burden to show it. You must show how it's economic, and you must make a demonstration that your costs and your ability to produce the oil is feasible and can be done in a reasonable, now we're in a very reasonable time frame. The problem is it speculative? Is there a basis to make that contention? Does it meet the burden of proof required, which is preponderance of the evidence, or is it speculative? And here, in this case, Dr. Empoma, when you review the direct testimony that's been submitted, I think you would find that their claims are speculative, that there is no basis to contend, given the nature of the zone and the distribution of these minute oil accumulations, that there's any ability now or in the future to target those zones efficiently and effectively, let alone economically, to produce economic volumes of oil.
Thank you. Mr. Rubin, can you comment? I know you recommended that we do not really talk about the burden of proof. So based on Goodnine's submission, any advice? I mean, I'm a little bit confused here.
Okay. Commissioner Empoma, members of the commission, After hearing from all the council, I think as to burden of proof, I think what I said before still applies. That both sides, and certainly to Mr. Rankin's point, there was a lot of history that presupposes that injection was proper in the San Andreas. And perhaps that creates some sort of de facto, at least, burden, like why are we going against all these previous decisions? Strictly, that is not a burden of proof issue, though. And I still maintain that with respect to that part of the motion, I think the commission will be well served to simply hold it in abeyance, put it in the capable hands of Mr. Harwood, and to the extent that the burden of proof somehow is in his is part of his recommendation, he will do so. As to the other more substantive points raised by Mr. Rankin, Commissioner Mpoma, I'm not sure what to add to what I said before.
Thank you.
Mr. Melander, I know you have a question. Would this go to Mr. Mpoma's, Dr. Mpoma's?
I would like to just make a brief clarification, if I may, and read something to the commission regarding references to Deputy Director Powell, if that's acceptable, Mr. Chair.
Okay. I don't have a problem. Is it acceptable, Mr. Rubin?
Mr. Melander, members of the commission, to the extent I can on the fly help or interpret what you're saying, Mr. Melander, I will try to, but I'm limited as to what I can glean from it just from hearing you say it for the first time now.
I think this will be helpful. So in that same witness testimony disclosure, Deputy Director Powell stated a few paragraphs before the quoted sections. The OCD would specifically point out through the respective applications, one of the remedies sought is adverse actions regarding previously issued OCD orders pertinent to the operator's injection authority. Deputy Director Powell wishes to convey the importance of only doing so with an abundance of caution, and then offers some of that testimony you saw excerpt. To frame that up, that was not OCD speaking on the burden of proof on scope here necessarily. This was in the framework of Deputy Director Powell effectively being what amounts to a 12B6 witness to discuss the history, background, things of that nature. And so the scope of that testimony is quite broad, and I wanted to ensure the commission understood that.
Thank you, Mr. Melander. Appreciate that. Clarification, Dr. Mpoma, you have.
Yes. So is OCD trying to dissociate, let's say, the arguments from the statement that the deputy director made?
Not quite, Dr. Mpoma. What Deputy Director Powell was saying, and again, I want to be cautious here because we are literally wandering into a evidentiary hearing at this point, which I am slightly uncomfortable with.
As am I. I really would like to keep the recitation of file testimony to a minimum. I don't think it's fair to Empire what Mr. Rankin has been citing to. I think we should really keep this.
Then I'm okay.
clean.
I'm okay.
Yeah.
Thank you.
Thank you, Mr. Rubin.
So I think in short, the statement is noted, Mr. Melander. Thank you. Any other
Thank you, Mr.
questions,
Chair.
commissioners? Okay. Thank you, Mr. Rankin. Last but not least, Mr. Beck, did you have anything you'd like to add?
Commissioners, I don't have much to add. I think that Mr. Rankin makes a good point about the sort of ad hoc nature that this has arisen with. And I think Mr. Rubin is correct that it might be best just to hold this at abeyance. I expect that after the hearing on these matters, there will be proposed findings of fact and conclusions of law. And at that point, I think the parties will be able to put together succinctly their arguments as to what the findings of fact from the hearing are and how those fit into the conclusions of law for the hearing officer to decide on and the commission ultimately to decide on. And I expect that playing into that will be the definitions of waste and correlative rights, both of which talk about the amount of oil and gas ultimately recovered for waste and recoverable oil and gas for correlative rights. And so it does not just talk about the waste of oil and gas or correlative rights being oil and gas, it talks about recovery. And I expect that the case law would bear out that there is some burden of proof, and I don't mean that precisely. I mean that the party will have to prove to move forward with their applications for injection permits or their applications to revoke permits, whether they have proved that there is waste to ultimately recovered oil and gas, or it affects the correlative rights of recoverable oil and gas. And so that definition will be borne out, I expect, in that briefing after the fact, to see how the findings of fact from the hearing fit into those conclusions of law. So I think it's important for the commission to recognize that there is, I expect, a process in place already for a more precise meeting of the burden of proof, of preponderance of the evidence, which I think everyone agrees is on each party in its respective applications.
Thank you, Mr. Beck. Appreciate it. Any questions on what Mr. Beck stated? Commissioners? No.
No.
Okay.
May I briefly respond to Mr. Rankin's points?
Please, Ms. Hardy. Yes.
Thank you. So I wanted to explain a little bit about why we filed this motion. And the reason we filed it is that Goodnight has been filing motions, and those have evolved over time. And their motions to compel, I believe, or where they raise this issue, they've repeatedly argued that Empire cannot prevail unless it proves a loss of production and paying quantities. So they repeatedly raise this issue. And because that is the Oil and Gas Act is broader than that, right? It gives the commission authority to prevent waste and protect correlative rights, however those are defined, and they are defined in the statute. And so that is why we filed the motion. We wanted to make it clear or request clarification that Goodnight has been misconstruing what actually has to be proven in these cases. And we are not, like I explained before, we're not taking the position that economics are not a factor. We have provided that testimony. Mr. Rankin's incorrect. Our statement of William West and his attachments goes into detail on the amount and the value of lost production. So we have provided that. We're not disassociating ourselves from economics. We've provided that information. But here, Goodnight has persisted in arguing, well, that's not production and paying quantities. That's not sufficient. So they keep making this argument. And so we filed this motion to sort of head that off and ask for clarification on what we actually have to prove at the hearing to prevent everyone from wasting time. So that is why we filed the motion. So we were asking for a clarification that the standard here is whether the injection results in waste and impairs correlative rights. And I think Mr. Rankin is ignoring the fact that Goodnight is seeking relief in these cases. They have filed 4 applications for authorization to inject. Those are applications they currently don't have that authority. They are asking for that. That's affirmative relief that they are asking for. And they are also asking for authorization to increase their injection rate. So they are asking to change the status quo and for authority that doesn't currently exist. So to put the entire burden on Empire, as they are trying to do, is simply, it's inconsistent with the law. And with respect to Mr. Rankin's discussion of Empire seeking a massive undoing of injection authority, I disagree with that as well, because historically, these volumes that Goodnight is injecting have not been injected into the San Andres. These are massive volumes of water that have come up in the last couple of years with Goodnight's applications and their current applications that are pending. So I don't think that Mr. Rankin's characterization of that is correct. And I think Mr. Rankin also forgets that the division already ruled against Goodnight in the Piazza case, because the division found that the injection would result in waste and impair correlative rights. So I think that's another thing that he's ignoring. I think to the extent Mr. Rankin argued that we should brief these issues further, I don't think that's necessary. We have fully briefed this issue. Goodnight filed a 20-page response to our motion. So I think that there is sufficient briefing for the commission to consider, and we would just ask for clarification of these issues, which is that the standard that applies is whether the injection results in waste and impairs correlative rights, and that each party bears the burden of proof on their own applications. So, thank you.
Go ahead. Thank you, Ms. Hardy. Commissioner Bloom has a question.
Ms. Hardy to you, and then maybe we'll go back to Mr. Rankin. But Ms. Hardy, I'm struggling with this. I guess any of the parties here could say or file a motion discussing what they believe the other side must show, be it loss of production in paying quantities or something else. But what our order says is that the parties shall submit all evidence, testimony, and legal argument on the issue of the existence, the extent of, and possible interference with a residual oil zone, the Eunice Monument South unit, by produced water injection activities undertaken by Goodnight. I mean, to my mind, that's pretty clear. And I think it points towards, although it doesn't specifically state, that this would be a hearing where we're looking to see the preponderance of the evidence. Just wanted to get your reaction to that.
And thank you, Commissioner Bloom. I agree. I think that is what the commission set out as the scope of the hearing, and that is part of what gave rise to us filing this motion, because I think that's a broader inquiry, and I think that is the appropriate inquiry, and I think it encompasses the concepts of waste and correlative rights, and that language is part of the reason we filed this motion, is that we felt like Goodnight's repeated arguments on this issue that Empire can't prevail unless it shows a reduction of production in paying quantities was inconsistent with that provision of the order.
Mr. Rankin?
Mr. Boone, would you mind repeating your question to me just so I make sure I understand?
Yes, my question was, I guess either side could put forth a motion stating what they believe the other side and other parties must show in this case, be it loss of production in paying quantities or other issues. But we do have an order here from the commission which states that the parties shall submit evidence about the existence and the extent and possible interference of an ROZ and the effects on that of water injection activity should it exist, right?
Yeah. Okay, understood. So on that point, I guess my response to that, Mr. Bloom, is that is an issue that the commission wants the parties to address, but it can't be the legal standard against which that decision is made, right? It's just an issue that we are meant to address before the commission and present facts and evidence and testimony and legal arguments around it, but it doesn't define the legal standard against which the commission must make its decision, right? That's something that we have to look to the statutes. We have to look to interpretation of the Oil and Gas Act to evaluate what the burden of proof is, what the legal standards are that each side must demonstrate. So my point, I guess, is simply that it's a representation of what you want to hear from us, right? In terms of what the evidence should go towards, but ultimately the decision has to be based on legal standards, right? And that goes to the statutes and the regulations that govern, or the UIC primacy authority, and that wasn't addressed in the scope of the order, the order on the scope of the hearing. And so that's, I think, what Empire was seeking to do here, was to kind of redefine or define what the legal standards should be, or have clarification on that. And my view is, like what Mr. Beck was saying, is I think that In the normal course, that's usually addressed in the closing briefs or arguments based on what the facts show, and then the council makes an argument about whether or not those facts or the showing of the evidence is sufficient to make out each party's case. So my answer to you is, I understand that the commission had an intent to have a broad showing of the evidence, and I don't disagree. My only point is that what the legal standards are that determines the decision is something that you have to look to the statutes for. And one other thing I want to mention, just respond to, is the Piazza order that the division issued did not make a finding that there was waste or impairment of private rights. What it found was that Empire had made a sufficient showing to defer that issue, basically. It didn't find that there was waste, didn't find there was impairment of rights. It said that there's a potential for additional production, and they deferred the issue. So there was no finding because there was no evidence in the record of waste or economics. So there wasn't a finding that the division made. Number one. And number two, Empire does not gain the benefit of, it's a de novo hearing. So in other words, it's from fresh. And so all we have to do is establish through preponderance of the evidence that injection is proper. We don't have to overcome any other higher burden of proof in order to achieve our authority to inject under that case. It's a de novo case. It means that we start afresh, and so that we don't have to overcome any higher burden in order to prevail in that case.
All right, thank you both. Chair.
Any other questions?
No.
Okay.
Mr. Commissioner, members of the Mr. Chair, members of the commission. So I think at this point, the commission has a few options in front of it. Just pointing them out again. Again, I think with respect to making any written decision on the burdens of proof, I don't think is necessary. Again, I think that's premature. It may not come up. I know that courts never want to decide issues they don't have to decide. There's a certain amount of judicial restraint there that would apply here too. As to the rest of it, if the commission has a sense of how it now wants to interpret the statutes at issue, we could formulate an order to that effect if at the commission's pleasure. We always have the option of going into closed session to carefully construct such an order, or we could hold this whole, as pointed out, we could hold the motion in abeyance. I think the hearing officer has been listening to our entire conversation as well, this entire colloquially. And so it may be sufficient to simply let this rest for now. And I mean, we are backloading this to a certain extent, but put this in the hands of the hearing officer with the benefit of this informed discussion on the legal issues. Was that too wordy?
No, it was not too wordy. I think it was a lot to think about for commissioners.
Yeah, there are a lot of legal issues in here. So I would prefer a closed session for us to discuss this.
Commissioner Bloom?
Mr. Chair, I'd be fine with Dr. Ampoma's proposal.
Okay, so under the Open Meetings Act, if we could have a motion to go into closed session to discuss under the authority of the Open Meetings Act, this adjudicatory matter, specifically and solely the issues on the agenda.
Mr. Rubin, I so move.
I second.
And we will need a roll call. And I just want to finish the motion. I just want to identify the agenda item for the motion. It would be, well, they're not numbered. The items, the consolidated cases as identified in the agenda. So if I could have a roll call vote based upon that motion.
We'll start with the roll call vote. Dr. Ampoma?
Approved.
Commissioner Bloom?
Approve.
And I, as the commission chair, approve as well.
Okay, we are now in closed session. As a practical matter, it might be fairer to leave. There's only 4 of us. There's many more of them. Is there another room we could go into?
We could go upstairs to the OCD conference room.
Okay. We are now in closed session. We will inform you all when we are back.
Yes. Nice. Well done.
I didn't know you had massage chairs in the.
Got the turn by nod, I guess.
So everyone's back. Who are we missing? Mr. Suazo? Oh, there he is. All right, Mr. Chair, members of the commission, I believe we are back in open session. I would just like the record to reflect that the only matters discussed in closed session were those listed in the motion and that no final actions were taken. I understand from deliberations in closed session that the commission would like to entertain a motion to hold in abeyance Empire's motion pending the recommendations of the hearing officer at the hearing.
I so move.
I second.
You need me to, do we need a roll call on this one?
No, you only need a roll call if it's to go into closed session or if
Okay.
one members, you could just simply do all in favor, say aye.
Aye.
No, any opposed? Motion passes. Back to you, Mr. Chair.
Great. Thank you. Okay, so that brings that case to completion. Mr. Rankin.
Sorry, just there's one housekeeping matter that the parties have discussed. And I just want to bring to the commission's attention as to that case. You may recall that the commission did issue an order directing Goodnight to produce records reflecting its injection rates for certain wells that Empire claimed were in violation of its authorizations to inject. The way the order read was that Goodnight should produce those records at or before the hearing on these cases. Now the hearing's been continued out to February. It was a little vague whether, nevertheless, the deadline was still to produce that information by today. So I'd conferred. It occurred to me after some time, a bit before the weekend, that there may be some clarification about when we should do so. Now, I've conferred with the Division Council and with Goodnight Council, Empire Council. And my understanding is that both Division Council and Empire Council believe that they'd like to see that data before the February hearing. And so I'll confer with the client, but I think we can get that data produced within 2 weeks from today's date. And I just want to bring that up as an order of housekeeping. So the commission was aware that we have not neglected that obligation, and that there was some discussion about what the intent was based on the fact that the hearing date has been moved out. So just want to make clear that we will go ahead and produce that data. I think there's 6 wells, and do so within 2 weeks from today, based on discussion with the parties, if that's acceptable.
It is from the
Okay.
division.
So we got a confirmation from the OCD, Mr. Shaheen.
We are in agreement with producing it within a couple of weeks. And I would also note that the order does state that the hearing examiner would, or the hearing officer would provide a report after receipt of that information. I don't believe that the hearing examiner is required to wait until the hearing to provide that report. But I just note that that is part of the order.
Okay.
And there is, if I may briefly, one other housekeeping issue. The parties are working on a revised and updated scheduling order based on the initial one.
Okay.
I'm assuming that'll be tendered and can be dealt with at an upcoming commission meeting.
Okay, so you'll keep us posted.
Yes, Mr. Chair.
Okay. Anything else on this particular case? Great. Thank you, everybody. Appreciate it. Our next order of business is any pending litigation that we may have.
Mr. Chair, members of the commission, nothing to report. No updates there.
Okay, excellent. Any other business that we have? Okay, I hear none for that. Our next meeting is going to be October the 9th, 2024. So this meeting is officially adjourned. Thank you, everybody. Gentlemen, thank you.